Article 1577. The redhibitory action based on the faults or defects of animals must be brought within 40 days from the date of their delivery to the vendee. This action can only be exercised with respect to faults and defects which are determined by law or by local customs. Article 1578. If the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused death existed at the time of the contract. Article 1579. If the sale be rescinded, the animal shall be returned in the condition in which it was sold and delivered, the vendee being answerable for any injury due to his negligence and not arising from the redhibitory fault or defect. Article 1580. In the sale of animals with redhibitory defects, the vendee shall also enjoy the right mentioned in Article 1567, but he must make use thereof within the same period which has been fixed for the exercise of the redhibitory action. Article 1581. The form of sale of large cattle shall be governed by special laws. Chapter 5. Obligations of the vendee. Article 1582. The vendee is bound to accept delivery and to pay the price of the thing sold at the time and place stipulated in the contract. If the time and place should not have been stipulated, the payment must be made at the time and place of the delivery of the thing sold. Article 1583. Unless otherwise agreed, the buyer of goods is not bound to accept delivery thereof by installments. Where there is a contract of sale of goods to be delivered by stated installments, which are to be separately paid for, and the seller makes defective deliveries in respect of one or more installments, or the buyer neglects or refuses without just cause to take delivery of or pay for one or more installments, it depends in each case on the terms of the contract and the circumstances of the case, whether the breach of contract is so material as to justify the injured party in refusing to proceed further and suing for damages for breach of the entire contract, or whether the breach is severable, giving rise to a claim for compensation, but not to a right to treat the whole contract as broken. Article 1584. Where goods are delivered to the buyer, which he has not previously examined, he is not deemed to have accepted them unless and until he has had a reasonable opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract, if there is no stipulation to the contrary. Unless otherwise agreed, when the seller tenders delivery of goods to the buyer, he is bound, on request, to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. Where goods are delivered to a carrier by the seller in accordance with an order from or agreement with the buyer, upon the terms that the goods shall not be delivered by the carrier to the buyer until he has paid the price, whether such terms are indicated by marking the goods with the words "collect on delivery" or otherwise, the buyer is not entitled to examine the goods before the payment of the price, in the absence of agreement or usage of trade permitting such examination. Article 1585. The buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them, or when the goods have been delivered to him, and he does any act in relation to them which is inconsistent with the ownership of the seller, or when after the lapse of a reasonable time he retains the goods without intimating to the seller that he has rejected them. Article 1586. In the absence of express or implied agreement of the parties, acceptance of the goods by the buyer shall not discharge the seller from liability in damages or other legal remedy for breach of any promise or warranty in the contract of sale. But if after acceptance of the goods, The buyer fails to give notice to the seller of the breach in any promise of warranty within a reasonable time after the buyer knows, or ought to know, of such breach, the seller shall not be liable therefor. Article 1587. Unless otherwise agreed, where goods are delivered to the buyer and he refuses to accept them, having the right so to do, he is not bound to return them to the seller, but it is sufficient if he notifies the seller that he refuses to accept them. If he voluntarily constitutes himself a depositary thereof, he shall be liable as such. Article 1588. If there is no stipulation as specified in the first paragraph of Article 1523, when the buyer's refusal to accept the goods is without just cause, the title thereto passes to him from the moment they are placed at his disposal. Article 1589. The vendee shall owe interest for the period between the delivery of the thing and the payment of the price in the following three cases. 1. Should it have been so stipulated. 2. Should the thing sold and delivered produce fruits or income. 3. Should he be in default from the time of judicial or extrajudicial demand for the payment of the price. Article 1590. Should the vendee be disturbed in the possession or ownership of the thing acquired, or should he have reasonable grounds to fear such disturbance, by a vindicatory action or a foreclosure of mortgage, he may suspend the payment of the price until the vendor has caused the disturbance or danger to cease, unless the latter gives security for the return of the price in a proper case, or it has been stipulated that, notwithstanding any such contingency, the vendee shall be bound to make the payment. A mere act of trespass shall not authorize the suspension of the payment of the price. Article 1591. Should the vendor have reasonable grounds to fear the loss of immovable property sold and its price, he may immediately sue for the rescission of the sale. Should such ground not exist, the provisions of Article 1191 shall be observed. Article 1592. In the sale of immovable property, even though it may have been stipulated that upon failure to pay the price at the time agreed upon, the rescission of the contract shall, of right, take place. The vendee may pay even after the expiration of the period as long as no demand for rescission of the contract has been made upon him, either judicially or by a notarial act. After the demand, the court may not grant him a new term. Article 1593. With respect to movable property, the rescission of the sale shall of right take place in the interest of the vendor. If the vendee, upon the expiration of the period fixed for the delivery of the thing, should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time, unless a longer period has been stipulated for its payment. Actions for breach of contract of sale of goods. Article 1594. Actions for breach of the contract of sale of goods shall be governed particularly by the provisions of this chapter, and as to matters not specifically provided for herein, by other applicable provisions of this title. Article 1595. Where, under a contract of sale, the ownership of the goods has passed to the buyer, and he wrongfully neglects or refuses to pay for the goods according to the terms of the contract of sale, the seller may maintain an action against him for the price of the goods. Where, under a contract of sale, the price is payable on a certain day, irrespective of delivery or of transfer of title, and the buyer wrongfully neglects or refuses to pay such price, the seller may maintain an action for the price although the ownership in the goods has not passed. But it shall be a defense to such an action that the seller at any time before the judgment in such action has manifested an inability to perform the contract of sale on his part, or an intention not to perform it. Although the ownership in the goods has not passed, if they cannot readily be resolved for a reasonable price, and if the provisions of Article 1596, fourth paragraph, are not applicable, the seller may offer to deliver the goods to the buyer, and if the buyer refuses to receive them, may notify the buyer that the goods are thereafter held by the seller as bailee for the buyer. Thereafter, the seller may treat the goods as the buyer's and may maintain an action for the price. Article 1596. Where the buyer wrongfully neglects or refuses to accept and pay for the goods, the seller may maintain an action against him for damages for non-acceptance. The measure of damages is the estimated loss directly and naturally resulting in the ordinary course of events from the buyer's breach of contract. Where there is an available market for the goods in question, the measure of damages is, in the absence of special circumstances showing proximate damage, of a different amount. The difference between the contract price in the market or current price at the time or times when the goods ought to have been accepted, or if no time was fixed for acceptance, then at the time of the refusal to accept. If, while labor or expense of material amount is necessary on the part of the seller to enable him to fulfill his obligations under the contract of sale, the buyer repudiates the contract or notifies the seller to proceed no further therewith, the buyer shall be liable to the seller for labor performed or expenses made before receiving notice of the buyer's repudiation or countermand. The profit the seller would have made if the contract or the sale had been fully performed shall be considered in awarding the damages. Article 1597. Where the goods have not been delivered to the buyer, and the buyer has repudiated the contract of sale, or has manifested his inability to perform his obligations thereunder, or has committed a breach thereof, the seller may totally rescind the contract of sale by giving notice of his election so to do to the buyer. Article 1598. Where the seller has broken a contract to deliver specific or ascertained goods, a court may, on the application of the buyer, direct that the contract shall be performed specifically without giving the seller the option of retaining the goods on payment of damages. The judgment or decree may be unconditional or upon such terms and conditions as to damages, payment of the price and otherwise, as the court may deem just. Article 1599. Where there is a breach of warranty by the seller, the buyer may at his election 1. Accept or keep the goods and set up against the seller the breach of warranty by way of recoupment and diminution or extinction of the price. Number 2. Accept or keep the goods and maintain an action against the seller for damages for the breach of warranty. 3. Refuse to accept the goods and maintain an action against the seller for damages for the breach of warranty. Number 4. Rescind the contract of sale and refuse to receive the goods, or if the goods have already been received, return them or offer to return them to the seller and recover the price or any part thereof which has been paid. When the buyer has claimed and been granted a remedy in any one of these ways, no other remedy can thereafter be granted, without prejudice to the provisions of the second paragraph of Article 1191. Where the goods have been delivered to the buyer, he cannot rescind the sale if he knew of the breach of warranty when he accepted the goods without protest, or if he fails to notify the seller within a reasonable time of the election to rescind, or if he fails to return or to offer to return the goods to the seller in substantially as good condition as they were in at that time the ownership was transferred to the buyer. But if deterioration or injury of the goods is due to the breach of warranty, such deterioration or injury shall not prevent the buyer from returning or offering to return the goods to the seller and rescinding the sale. Where the buyer is entitled to rescind the sale and elects to do so, he shall cease to be liable for the price upon returning or offering to return the goods. If the price or any part thereof has already been paid, the seller shall be liable to repay so much thereof as has been paid, concurrently with the return of the goods, or immediately after an offer to return the goods, in exchange for repayment of the price. where the buyer is entitled to rescind the sale and elects to do so. If the seller refuses to accept an offer of the buyer to return the goods, the buyer shall thereafter be deemed to hold the goods as bailey for the seller, but subject to a lien to secure the payment of any portion of the price which has been paid, and with the remedies for the enforcement of such lien allowed to an unpaid seller by Article 1526. Number 5. In the case of breach of warranty of quality, such loss, in the absence of special circumstances showing proximate damage of a greater amount, is the difference between the value of the goods at the time of delivery to the buyer and the value they would have had if they had answered to the warranty. Chapter 7. Extinguishment of sale. Article 1600. Sales are extinguished by the same causes as all other obligations by those stated in the preceding articles of this title, and by conventional or legal redemption. Section 1. Conventional redemption. Article 1601. Conventional redemption shall take place when the vendor reserves the right to repurchase the things sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. Article 1602. The contract shall be presumed to be an equitable mortgage in any of the following cases. 1. When the price of a sale with right to repurchase is unusually inadequate. 2. When the vendor remains in possession as lessee or otherwise. 3. When upon or after the expiration of the right to repurchase another instrument extending the period of redemption or granting a new period is executed. 4. When the purchaser returns for himself a part of the purchase price. 5. When the vendor binds himself to pay the taxes on the things sold. 6. In any other case where it may be fairly inferred that the real intention of the parties is that the transaction shall secure the payment of a debt or the performance of any other obligation. In any of the foregoing cases, any money, fruits, or other benefits to be received by the vendee as rent or otherwise shall be considered as interest, which shall be subject to the usury laws. Article 1603. In case of doubt, a contract purporting to be a sale with right to repurchase shall be construed as an equitable mortgage. Article 1604. The provisions of Article 1602 shall also apply to a contract purporting to be an absolute sale. Article 1605. In the cases referred to in Articles 1602 and 1604, the apparent vendor may ask for the reformation of the instrument. Article 1606. The right referred to in Article 1601, in the absence of an express agreement, shall last 4 years from the date of the contract. Should there be an agreement, the period cannot exceed 10 years. However, the vendor may still exercise the right to repurchase within 30 days from the time final judgment was rendered in a civil action on the basis that the contract was a true sale with right to repurchase. Article 1607. In case of real property, the consolidation of ownership in the vendee by virtue of the failure of the vendor to comply with the provisions of Article 1616, shall not be recorded in the Registry of Property without a judicial order, after the vendor has been duly heard. Article 1608. The vendor may bring his action against every possessor whose right is derived from the vendee, even if in the second contract no mention should have been made of the right to repurchase, without prejudice to the provisions of the mortgage law and the land registration law with respect to third persons. Article 1609. The vendee is subrogated to the vendor's rights and actions. Article 1610. The creditors of the vendor cannot make use of the right of redemption against the vendee until after they have exhausted the property of the vendor. Article 1611. In a sale with a right to repurchase, the vendee of a part of an undivided immovable, who acquires the whole thereof, in the case of Article 498, may compel the vendor to redeem the whole property if the latter wishes to make use of the right of redemption. Article 1612. If several persons jointly and in the same contract should sell an undivided immovable with a right of repurchase, none of them may exercise his right for more than his respective share. The same rule shall apply if the person who sold an immovable alone has left several heirs, in which case each of the latter may only redeem the part which he may have acquired. Article 1613. In the case of the preceding article, the vendee may demand of all the vendors or co-heirs that they come to an agreement upon the repurchase of the whole thing sold, and should they fail to do so, the vendee cannot be compelled to consent to a partial redemption. Article 1614. Each one of the co-owners of an undivided immovable who may have sold his share separately may independently exercise the right of repurchase as regards his own share, and the vendee cannot compel him to redeem the whole property. Article 1615. If the vendee should leave several heirs, the action for redemption cannot be brought against each of them except for his own share, whether the thing be undivided or it has been partitioned among them. But if the inheritance has been divided and the thing sold has been awarded to one of the heirs, the action for redemption may be instituted against him for the whole. Article 1616. The vendor cannot avail himself of the right of repurchase without returning to the vendee the price of the sale, and in addition, 1. The expenses of the contract, and any other legitimate payments made by reason of the sale. 2. The necessary and useful expenses made on the thing sold. Article 1617. If at the time of the execution of the sale there should be on the land visible or growing fruits, there shall be no reimbursement for or prorating of those existing at the time of redemption, if no indemnity was paid by the purchaser when the sale was executed. Should there have been no fruits at the time of the sale, and some exist at the time of redemption, they shall be prorated between the redemptioner and the vendee, giving the latter the part corresponding to the time he possessed the land in the last year, counted from the anniversary of the date of the sale. Article 1618. The vendor who recovers the thing sold shall receive it free from all charges or mortgages constituted by the vendee, but he shall respect the leases which the latter may have executed in good faith, and in accordance with the custom of the place where the land is situated. Section 2. Legal redemption. Article 1619. Legal redemption is the right to be subrogated upon the same terms and conditions stipulated in the contract, in the place of one who acquires the thing by purchase or adhesion in payment, or by any other transaction whereby ownership is transmitted by onerous title. Article 1620. A co-owner of a thing may exercise the right of redemption in case the shares of all the other co-owners, or any of them, are sold to a third person. If the price of the alienation is grossly excessive, the redemptioner shall pay only a reasonable one. Should two or more co-owners desire to exercise the right of redemption, they may only do so in proportion to the share they may respectively have in the thing owned in common. Article 1621. The owners of adjoining lands shall also have the right of redemption when a piece of rural land, the area of which does not exceed 1 hectare, is alienated unless the grantee does not own any rural land. This right is not applicable to adjacent lands which are separated by brooks, drains, ravines, roads, and other apparent servitudes for the benefit of other states. If two or more adjoining owners desire to exercise the right of redemption at the same time, the owner of the adjoining land of smaller area shall be preferred, and should both lands have the same area, the one who first requested the redemption. Article 1622. Whenever a piece of urban land, which is so small and so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time, having been bought merely for speculation, is about to be resold, the owner of any adjoining land has a right of pre-emption at a reasonable price. If the resale has been perfected, the owner of the adjoining land shall have a right of redemption also at a reasonable price. When two or more owners of adjoining lands wish to exercise the rights of preemption or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. Article 1623. The right of legal preemption or redemption shall not be exercised except within 30 days from the notice in writing by the prospective vendor or by the vendor, as the case may be. The deed of sale shall not be recorded in the registry of property unless accompanied by an affidavit of the vendor that he has given written notice thereof to all possible redemptioners. The right of redemption of co-owners excludes that of adjoining owners. Chapter 8. Assignment of credits and other incorporeal rights. Article 1624. An assignment of credits and other incorporeal rights shall be perfected in accordance with the provisions of Article 1475. Article 1625. An assignment of a credit, right, or action shall produce no effect as against third persons unless it appears in a public instrument, or the instrument is recorded in the registry of property in case the assignment involves real property. Article 1626. The debtor who, before having knowledge of the assignment, pays his creditor shall be released from the obligation. Article 1627. The assignment of a credit includes all the accessory rights, such as a guarantee, mortgage, pledge, or preference. Article 1628. The vendor, in good faith, shall be responsible for the existence and legality of the credit at the time of the sale, unless it should have been sold as doubtful, but not for the solvency of the debtor, unless it has been so expressly stipulated, or unless the insolvency was prior to the sale and of common knowledge. Even in these cases he shall only be liable for the price received and for the expenses specified in number 1 of Article 1616. The vendor in bad faith shall always be answerable for the payment of all expenses and for damages. Article 1629. In case the assigner in good faith should have made himself responsible for the solvency of the debtor, and the contracting parties should not have agreed upon the duration of the liability, it shall last for 1 year only, from the time of the assignment, if the period had already expired. If the credit should be payable within a term or period which has not yet expired, the liabilities shall cease 1 year after the maturity. Article 1630. One who sells an inheritance without enumerating the things of which it is composed shall only be answerable for his character as an heir. Article 1631. One who sells for a lump sum the whole of certain rights, rents, or products shall comply by answering for the legitimacy of the whole in general, but he shall not be obliged to warrant each of the various parts of which it may be composed, except in the case of eviction from the whole or the part of greater value. Article 1632. Should the vendor have profited by some of the fruits, or received anything from the inheritance sold, he shall pay the vendee thereof, if the contrary has not been stipulated. Article 1633. The vendee shall, on his part, reimburse the vendor for all that the latter may have paid for the debts of and charges on the estate, and satisfy the credits he may have against the same, unless there is an agreement to the contrary. Article 1634. When a credit or other incorporeal right in litigation is sold, and the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid therefor, the judicial costs incurred by him, and the interest on the price from the day on which the same was paid. A credit or other incorporeal right shall be considered in litigation from the time the complaint concerning the same is answered. The debtor may exercise his right within 30 days from the date the assignee demands payment from him. Article 1635. From the provisions of the preceding article shall be excepted the assignments or sales made, 1. To a co-heir or co-owner of the right assigned. 2. To a creditor in payment of his credit. 3. To the possessor of a tenement or piece of land which is subject to the right in litigation assigned. Chapter 9. General Provisions. Article 1636. In the preceding articles, in this title governing the sale of goods, unless the context or subject matter otherwise requires. 1. Document of title to goods. Includes any bill of lading, dock warrant, kidan, or warehouse receipt, or order for the delivery of goods, or any other document used in the ordinary course of business in the sale or transfer of goods, as proof of the possession or control of the goods, or authorizing or purporting to authorize the possessor of the document to transfer or receive, either by endorsement or by delivery, goods represented by such document. Goods includes all chattels, personal, but not things, in action or money of legal tender in the Philippines. The term includes growing fruits or crops. Order relating to documents of title means an order by endorsement on the documents. Quality of goods includes their state or condition. Specific goods means goods identified and agreed upon at the time a contract of sale is made. An antecedent or pre-existing claim, whether for money or not, constitutes value, where goods or documents of title are taken either in satisfaction thereof or as security therefor. 2. A person is insolvent within the meaning of this title who either has ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether insolvency proceedings have been commenced or not. 3. Goods are in a deliverable state within the meaning of this title when they are in such a state that the buyer would, under the contract, be bound to take delivery of them. Article 1637. The provisions of this title are subject to the rules laid down by the mortgage law and the land registration law with regard to immovable property. Title 7. Barter or exchange. Article 1638. By the contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. Article 1639. If one of the contracting parties, having received the thing promised him in barter, should prove that it did not belong to the person who gave it, he cannot be compelled to deliver that which he offered in exchange, but he shall be entitled to damages. Article 1640. One who loses by eviction the thing received in barter may recover that which he gave in exchange with the right to damages, or he may only demand an indemnity for damages. However, he can only make use of the right to recover the thing which he has delivered while the same remains in the possession of the other party, and without prejudice to the rights acquired in good faith in the meantime by a third person. Article 1641. As to all matters not specifically provided for in this title, barter shall be governed by the provisions of the preceding title relating to sales. Title 8. Lease. Chapter 1. General Provisions. Article 1642. The contract of lease may be of things or of work and service. Article 1643. In the lease of things, one of the parties binds himself to give to another the enjoyment or use of a thing for a price certain, and for a period which may be definite or indefinite. However, no lease for more than 99 years shall be valid. Article 1644. In the lease of work or service, one of the parties binds himself to execute a piece of work or to render to the other some service for a price certain, but the relation of principal and agent does not exist between them, Article 1645. Consumable goods cannot be the subject matter of a contract of lease, except when they are merely to be exhibited or when they are accessory to an industrial establishment. Chapter 2. Lease of Rule in Urban Lands. Section 1. General Provisions. Article 1646. The persons disqualified to buy referred to in Articles 1490 and 1491 are also disqualified to become lessees of the things mentioned therein. Article 1647. If a lease is to be recorded in the Registry of Property, the following persons cannot constitute the same without proper authority: the husband with respect to the wife's paraphernal real estate, the father or guardian as to the property of the minor or ward, and the manager without special power. Article 1648. Every lease of real estate may be recorded in the Registry of Property. Unless the lease is recorded, it shall not be binding upon third persons. Article 1649. The lessee cannot assign the lease without the consent of the lessor, unless there is a stipulation to the contrary. Article 1650. When in the contract of lease of things there is no express prohibition, the lessee may sublet the thing leased, in whole or in part, without prejudice to his responsibility for the performance of the contract toward the lessor. Article 1651. Without prejudice to his obligation toward the sublessor, the sublessee is bound to the lessor for all acts which refer to the use and preservation of the thing leased in the manner stipulated between the lessor and the lessee. Article 1652. The sublessee is subsidiarily liable to the lessor for any rent due from the lessee. However, the sublessee shall not be responsible beyond the amount of rent due from him, in accordance with the terms of the sublease, at the time of the extrajudicial demand by the lessor. Payments of rent in advance by the sublessee shall be deemed not to have been made, so far as the lessor's claim is concerned, unless said payments were effected in virtue of the custom of the place. Article 1653. The provisions governing warranty contained in the title of sales shall be applicable to the contract of lease. In the case where the return of the price is required, reduction shall be made in proportion to the time during which the lessee enjoyed the thing. Section 2. Rights and obligations of the lessor and the lessee. Article 1654. The lessor is obliged: 1. To deliver the thing which is the object of the contract in such a conditions as to render it fit for the use intended. 2. To make on the same during the lease all the necessary repairs in order to keep it suitable for the use to which it has been devoted, unless there is a stipulation to the contrary. 3. To maintain the lessee in the peaceful and adequate enjoyment of the lease for the entire duration of the contract. Article 1655. If the thing leased is totally destroyed by a fortuitous event, the lease is extinguished. If the destruction is partial, the lessee may choose between a proportional reduction of the rent and a rescission of the lease. Article 1656. The lessor of a business or industrial establishment may continue engaging in the same business or industry to which the lessee devotes the thing leased, unless there is a stipulation to the contrary. Article 1657. The lessee is obliged: 1. To pay the price of the lease according to the terms stipulated. 2. To use the thing leased as a diligent father of a family, devoting it to the use stipulated, and in the absence of stipulation to that which may be inferred from the nature of the thing leased, according to the custom of the place. 3. To pay the expenses for the deed of lease. Article 1658. The lessee may suspend the payment of the rent in case the lessor fails to make the necessary repairs, or to maintain the lessee in peaceful and adequate enjoyment of the property leased. Article 1659. If the lessor or the lessee should not comply with the obligations set forth in Articles 1654 and 1657, the aggrieved party may ask for the rescission of the contract and indemnification for damages, or only the latter, allowing the contract to remain in force. Article 1660. If a dwelling place or any other building intended for human habitation is in such a condition that its use brings imminent and serious danger to life or health, the lessee may terminate the lease at once by notifying the lessor, even if at the time of the contract was perfected the former knew of the dangerous condition or waived the right to rescind the lease on account of this condition. Article 1661. The lessor cannot alter the form of the thing leased in such a way as to impair the use to which the thing is devoted under the terms of the lease. Article 1662. If during the lease it should become necessary to make some urgent repairs upon the thing leased, which cannot be deferred until the termination of the lease, the lessee is obliged to tolerate the work, although it may be very annoying to him, and although during the same he may be deprived of a part of the premises. If the repairs last more than 40 days, the rent shall be reduced in proportion to the time, including the first 40 days, and the part of the property of which the lessee has been deprived. When the work is of such a nature that the portion which the lessee and his family need for their dwelling becomes uninhabitable, he may rescind the contract if the main purpose of the lease is to provide a dwelling place for the lessee. Article 1663. The lessee is obliged to bring to the knowledge of the proprietor, within the shortest possible time, every usurpation or untoward act which any third person may have committed, or may be openly preparing to carry out, upon the thing leased. He is also obliged to advise the owner with the same urgency of the need of all repairs included in number 2 of Article 1654. In both cases, the lessee shall be liable for the damages which, through his negligence, may be suffered by the proprietor. If the lessor fails to make urgent repairs, the lessee, in order to avoid an imminent danger, may order the repairs at the lessor's cost. Article 1664. The lessor is not obliged to answer for a mere act of trespass, which a third person may cause on the use of the thing leased, but the lessee shall have a direct action against the intruder. There is a mere act of trespass when the third person claims no right whatever. Article 1665. The lessee shall return the thing leased upon the termination of the lease, just as he received it, save what has been lost or impaired by the lapse of time, or by ordinary wear and tear, or from an inevitable cause. Article 1666. In the absence of a statement concerning the condition of the thing at the time the lease was constituted, the law presumes that the lessee received it in good condition unless there is proof to the contrary. Article 1667. The lessee is responsible for the deterioration of loss or the thing leased unless he proves that it took place without his fault. This burden of proof on the lessee does not apply when the destruction is due to earthquake, flood, storm, or other natural calamity. Article 1668. The lessee is liable for any deterioration caused by members of his household and by guests and visitors. Article 1669. If the lease was made for a determinate time, it ceases upon the day fixed without the need of a demand. Article 1670. If at the end of the contract the lessee should continue enjoying the thing leased for 15 days with the acquiescence of the lessor, and unless a notice to the contrary by either party has previously been given, it is understood that there is an implied new lease, not for the period of the original contract, but for the time established in Articles 1682 and 1687. The other terms of the original contract shall be revived. Article 1671. If the lessee continues enjoying the thing after the expiration of the contract, over the lessor's objection, the former shall be subject to the responsibilities of the possessor in bad faith. Article 1672. In case of an implied new lease, the obligation contracted by a third person for the security of the principal contract shall cease with respect to the new lease. Article 1673. The lessor may judicially eject the lessee for any of the following causes. 1. When the period agreed upon, or that which is fixed for the duration of lease under Articles 1682 and 1687 has expired. 2. Lack of payment of the price stipulated. 3. Violation of any of the conditions agreed upon in the contract. 4. When the lessee devotes the thing leased to any use or service not stipulated, which causes the deterioration thereof, or if he does not observe the requirement in number 2 of Article 1657 as regards the use thereof. The ejectment of tenants of agricultural lands is governed by special laws. Article 1674. In ejectment cases where an appeal is taken, the remedy granted in Article 539, second paragraph, shall also apply if the higher court is satisfied that the lessee's appeal is frivolous or dilatory, or that the lessor's appeal is prima facie meritorious. The period of 10 days referred to in said article shall be counted from the time the appeal is perfected. Article 1675. Except in cases stated in Article 1673, the lessee shall have a right to make use of the periods established in Articles 1682 and 1687. Article 1676. The purchaser of a piece of land, which is under a lease that is not recorded in the Registry of Property, may terminate the lease, save when there is a stipulation to the contrary in the contract of sale, or when the purchaser knows of the existence of the lease. If the buyer makes use of this right, the lessee may demand that he be allowed to gather the fruits of the harvest which corresponds to the current agricultural year, and that the vendor indemnify him for damages suffered. If the sale is fictitious for the purpose of extinguishing the lease, the supposed vendee cannot make use of the right granted in the first paragraph of this article. The sale is presumed to be fictitious if at the time the supposed vendee demands the termination of the lease, the sale is not recorded in the Registry of Property. Article 1677. The purchaser in a sale with the right of redemption cannot make use of the power to eject the lessee until the end of the period for the redemption. Article 1678. If the lessee makes, in good faith, useful improvements which are suitable to the use for which the lease is intended, without altering the form or substance of the property leased, the lessor, upon the termination of the lease, shall pay the lessee 1/2 of the value of the improvements at that time. Should the lessor refuse to reimburse that amount, the lessee may remove the improvements, even though the principal thing may suffer damage thereby. He shall not, however, cause any more impairment upon the property leased than is necessary. With regard to ornamental expenses, the lessee shall not be entitled to any reimbursement, but he may remove the ornamental objects, provided no damage is caused to the principal thing, and the lessor does not choose to retain them by paying their value at the time the lease is extinguished. Article 1679. If nothing has been stipulated concerning the place and the time for the payment of the lease, the provisions of Article 1251 shall be observed as regard the place, and with respect to the time, the custom of the place shall be followed. Section 3. Special provisions for leases of rural lands. Article 1680. The lessee shall have no right to a reduction of the rent on account of the sterility of the land leased, or by reason of the loss of fruits due to ordinary fortuitous events, but he shall have such right in case of the loss of more than 1/2 of the fruits through extraordinary and unforeseen fortuitous events, save always when there is a specific stipulation to the contrary. Extraordinary fortuitous events are understood to be fire, war, pestilence, unusual flood, locusts, earthquake, or other which are uncommon, and which the contracting parties could not have reasonably foreseen. Article 1681. Neither does the lessee have any right to a reduction of the rent if the fruits are lost after they have been separated from their stalk, root, or trunk. Article 1682. The lessee of a piece of rural land, when its duration has not been fixed, is understood to have been made for all the time necessary for the gathering of the fruits which the whole estate leased may yield in 1 year, or which it may yield once, although 2 or more years may have to elapse for the purpose. Article 1683. The outgoing lessee shall allow the incoming lessee or the lessor the use of the premises and other means necessary for the preparatory labor for the following year, and reciprocally, the incoming lessee or the lessor is under obligation to permit the outgoing lessee to do whatever may be necessary for the gathering or harvesting and utilization of the fruits, all in accordance with the custom of the place. Article 1684. Land tenancy on shares shall be governed by special laws, the stipulations of the parties, the provisions on partnership, and by the customs of the place. Article 1685. The tenant on shares cannot be ejected except in cases specified by law. Section 4. Special provisions for the lease of urban lands. Article 1686. In default of a special stipulation, the custom of the place shall be observed with regard to the kind of repairs on urban property for which the lessor shall be liable. In case of doubt, it is understood that the repairs are chargeable against him. Article 1687. If the period for the lease has not been fixed, it is understood to be from year to year. If the rent agreed upon is annual, from month to month. If it is monthly, from week to week. If the rent is weekly, and from day to day, if the rent is to be paid daily. However, even though a monthly rent is paid, and no period for the lease has been set, the courts may fix a longer term for the lease after the lessee has occupied the premises for over 1 year. If the rent is weekly, the courts may likewise determine a longer period after the lessee has been in possession for over 6 months. In case of daily rent, the courts may also fix a longer period after the lessee has stayed in the place for over 1 month. Article 1688. When the lessor of a house, or part thereof, used as a dwelling for a family, or when the lessor of a store or industrial establishment also leases the furniture, the lease of the latter shall be deemed to be for the duration of the lease of the premises. Chapter 3. Work and Labor, Section 1. Household Service. Article 1689. Household service shall always be reasonably compensated. Any stipulation that household service is without compensation shall be void. Such compensation shall be in addition to the house helper's lodging, food, and medical attendance. Article 1690. The head of the family shall furnish free of charge to the house helper suitable and sanitary quarters as well as adequate food and medical attendance. Article 1691. If the house helper is under the age of 18 years, the head of the family shall give an opportunity to the house helper for at least elementary education. The cost of such education shall be a part of the house helper's compensation, unless there is a stipulation to the contrary. Article 1692. No contract for household service shall last for more than 2 years. However, such contract may be renewed from year to year. Article 1693. The house helper's clothes shall be subject to stipulation. However, any contract for household service shall be void if thereby the house helper cannot afford to acquire suitable clothing. Article 1694. The head of the family shall treat the house helper in a just and humane manner. In no case shall physical violence be used upon the house helper. Article 1695. House helpers shall not be required to work more than 10 hours a day. Every house helper shall be allowed 4 days vacation each month with pay. Article 1696. In case of death of the house helper, the head of the family shall bear the funeral expenses if the house helper has no relatives in the place where the head of the family lives, with sufficient means, therefore. Article 1697. If the period for household service is fixed, neither the head of the family nor the house helper may terminate the contract before the expiration of the term, except for a just cause. If the house helper is unjustly dismissed, he shall be paid the compensation already earned, plus that for 15 days by way of indemnity. If the house helper leaves without justifiable reason, he shall forfeit any salary due him and unpaid for not exceeding 15 days. Article 1698. If the duration of the household service is not determined either by stipulation or by the nature of the service, the head of the family or the house helper may give notice to put an end to the service relation according to the following rules. 1. If the compensation is paid by the day, notice may be given on any day that the service shall end at the close of the following day. 2. If the compensation is paid by the week, notice may be given at the latest on the first business day of the week that the service shall be terminated at the end of the 7th day from the beginning of the week. Number 3. If the compensation is paid by the month, notice may be given at the latest on the 5th day of the month that the service shall cease at the end of the month. Article 1699. Upon the extinguishment of the service relation, the house helper may demand from the head of the family a reinstatement on the nature and duration of the service and the efficiency and conduct of the house helper. Section 2. Contract of Labor. Article 1700. The relation between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor, and similar subjects. Article 1701. Neither capital nor labor shall act oppressively against the other, or impair the interest or convenience of the public. Article 1702. In case of doubt, all labor legislation and all labor contracts shall be construed in favor of the safety and decent living of the laborer. Article 1703. No contract which practically amounts to involuntary servitude under any guise whatsoever shall be valid. Article 1704. In collective bargaining, the labor union or members of the board or committee signing the contract shall be liable for non-fulfillment thereof. Article 1705. The laborer's wages shall be paid in legal currency. Article 1706. Withholding of the wages, except for a debt due, shall not be made by the employer. Article 1707. The laborer's wages shall be a lien on the goods manufactured or the work done. Article 1708. The laborer's wages shall not be subject to execution or attachment, except for debts incurred for food, shelter, clothing, and medical attendance. Article 1709. The employer shall neither seize nor retain any tool or other articles belonging to the laborer. Article 1710. Dismissal of laborers shall be subject to the supervision of the government under special laws. Article 1711. Owners of enterprises and other employers are obliged to pay compensation for the death of or injuries to their laborers, workmen, mechanics, or other employees, even though the event may have been purely accidental or entirely due to a fortuitous cause, if the death or personal injury arose out of and in the course of the employment. The employer is also liable for compensation if the employee contracts any illness or disease caused by such employment, or as the result of the nature of the employment. If the mishap was due to the employee's own notorious negligence or voluntary act or drunkenness, the employer shall not be liable for compensation. When the employee's lack of due care contributed to his death or injury, the compensation shall be equitably reduced. Article 1712. If the death or injury is due to the negligence of a fellow worker, the latter and the employer shall be solidarily liable for compensation. If a fellow worker's intentional or malicious act is the only cause of the death or injury, the employer shall not be answerable, unless it should be shown that the latter did not exercise due diligence in the selection or supervision of the plaintiff's fellow worker.